Welcome to EPG Pathshala for the course on History and Ideologies of Social Work. My name is Murli Desai and I'm a former professor of Tata Institute of Social Sciences. Today's topic is social justice and human rights. In this topic, we will look at the ideology of social justice and human rights with reference to international human rights law, rights-based development, and human rights movement. The ideologies of social justice and human rights owe their evolution to the emerging middle-class quest for political and civil liberties within European civilizations. Although one can say social justice is prevalent all over the world historically in several kingdoms. But when we look at its implications in the contemporary times, it helps us to see its historical context of emergence in the European movements or revolutions that we have discussed earlier. In the 18th century, the concept of natural rights as political rights got deeply grounded with documents such as the American Independence and Declaration of Rights of 1781 and the French Declaration of the Rights of Man and of the Citizen of 1789. The Holocaust in Europe and Japanese atrocities in Asia also generated political momentum in the immediate post-Second World War years for the establishment of an international human rights protection system. The United Nations was founded in 1945 after the Second World War by 51 states. The United Nations was formed for this purpose in 1945 after the Second World War by 51 countries. Now let us see the historical context of the ideology of social justice. In Western thought and political language, the concept of social justice first surfaced during the development of the socialist doctrine. It emerged as an expression of protest against what was perceived as the capitalistic exploitation of labor and as a focal point for the development of measures to improve the human condition. Following the European revolutions, social justice became a rallying cry for progressive thinkers and political activists. Now, what does it mean? The UN report on social justice in an open world and the role of United Nations has used the language of rights of equality, equity, and inequality in reference to both positive objective of justice to be pursued and negative situations to be corrected. The UN report identified three areas of priority with regard to this. First is equality of rights, primarily implying the elimination of all forms of discrimination and respect for the fundamental freedoms and civil and political rights of all individuals. This represents the most fundamental form of equality. Second is equality of opportunities, which requires stable social, economic, cultural, and political conditions that enable all individuals to fulfill their potential and contribute to the economy and to the society. Third is equity in living conditions for all individuals and households. The UN report defined the more concrete elements requiring consideration in relation to the idea of social justice, which included the following. 1. Inequalities in distribution of income, inequalities in the distribution of assets, inequalities in the distribution of opportunities for work and remunerated employment, inequalities in the distribution of access to knowledge, inequalities in the distribution of health services, social security, and provision of a safe environment, and inequalities in the distribution of opportunities for civic and political participation. Now, let us see the concept of human rights. According to the UN, human rights could be generally defined as those rights that are inherent in our nature and without which we cannot live as human beings. As we are born, as soon as we are born, we have human rights. That's the implication. It allows us to fully develop and use our human qualities. It comprises of values obtained from different ideologies as follows. It obtained human dignity as a value from secular humanism, freedom as a value from liberalism, participation as a value from democracy, and equality as a value from socialism. The denial of human rights and fundamental freedoms is not only an individual and personal tragedy, but also creates a condition of social and political unrest, sowing the seeds of violence and conflict within and between societies and nations. What are the different principles of human rights? One is universality and inalienability, indivisibility, interdependence and interrelatedness, non-discrimination and equality, participation and inclusion, accountability, and the rule of law. Let us take each one of them now. What is the meaning of universality and inalienability? Human rights are universal and inalienable. What it means is all people everywhere in the world are entitled to human rights. The human person in her cannot voluntarily give them up, nor can others take them away from them. As stated in Article 1 of the First Declaration on Human Rights, all human beings are born free and equal in dignity and rights. The second principle is indivisibility. What does that mean? When human rights are considered indivisible, it means whether it's a civil right, cultural, economic, political, or social right, they are all inherent and all equal in status. You cannot say that I first want my civil right of being a citizen, then only I want my economic right, or first you get rid of my poverty, that is, give me my economic right, then only you make me a citizen. No. All these rights are equally important and they cannot be ranked. And they are indivisible, they cannot be separated out. The third set of principles are interdependence and interrelatedness. Although rights are listed separately, you cannot obtain a right without obtaining another right. Similar to the indivisibility, the realization of one right depends wholly or in part upon the realization of the other right. For example, as we saw earlier, if I am a citizen, if I have my civil and political rights, then I can claim my economic and social rights much more easily. Another example is realization of the right to health may depend in certain circumstances on realization of the right to education or the right to information. Equality and non-discrimination, again very important principles of human rights, which states that all individuals are equal as human beings and by virtue of the inherent dignity of every human person. And all human beings are entitled to human rights without discrimination by either race, color, sex, ethnicity, age, language, religion, political or other opinion, national or social origin, disability, property, birth or other status, as explained by the different human rights treaty bodies. Participation and inclusion, equally important principle for human rights, where every person and all peoples are entitled to active, free and meaningful participation in contribution to and enjoyment of civil, economic, social, cultural and political development in which human rights and fundamental freedoms can be realized. Human beings are not just beneficiaries of benefits given by either the state or the society. They participate in obtaining these benefits. Lastly, accountability and rule of law. States and other duty bearers are answerable for the observance of human rights. In this regard, they have to comply with the legal norms and standards enshrined in human rights instruments. Where they fail to do so, aggrieved right holders are entitled to institute proceedings for appropriate redressal before a competent court or other adjudicator in accordance with the rules and procedures provided by law. Now, what are these human rights instruments? Let us first look at the first human rights instrument that laid the foundation for human rights. The UN General Assembly adopted the Universal Declaration of Human Rights in 1948, following the 1945 Charter of the UN, which was drafted as a common standard of achievement for all peoples and all nations. For the first time in human history, the following was declared. The declaration emphasizes the universality of rights centered on the equality of all people. It recognizes the realization of human rights as a collective goal of humanity. It identifies a comprehensive range of all rights, civil, political, economic, social, and cultural, for all people. It creates an international system for promoting the realization of human rights with institutions to set standards, establish international laws, and monitor performance. It establishes the state's accountability for its human rights obligations and commitments under the international law. The second type of human rights instruments that are most important are the international covenants. In 1966, two covenants, which also mean agreements, were derived from the Universal Declaration of Human Rights, which we will call UDHR, which set out internationally recognized standards against which human rights violations can be judged. One is the International Covenant on Civil and Political Rights, which we will call CCPR, and second, the International Covenant on Economic, Social and Cultural Rights, which we will call the CECR. Now, the CCPR is the capitalist contribution that focuses on the liberal ideology. It includes right to life, freedom from torture, slavery, servitude, forced labor and unlawful arrest, freedom of movement, thought, opinion, conscience and religion, etc. The CESCR, on the other hand, is a contribution of the socialist lobby, which recommends state intervention for redistribution of resources. It emphasizes right to government provision for basic necessities, such as technical and vocational guidance and training programs, policies and techniques to achieve steady economic, social and cultural development, and full and productive employment. CESCR has not been ratified by the US even today, and therefore has not received as much attention at the UN as the CCPR has received, which has been basically the outcome of the capitalist lobby. However, things changed slightly when the newly independent southern countries meaning the former colonies, or the developing countries or the third world countries into the UN in the 1960s and the 1970s. This spurred the beginning of attempts to bridge the two domains of human rights, with the CESCR as an important starting point towards right to development. The UDHR and the two covenants form the basic international bill of human rights. Then a series of other international human rights treaties and other instruments adopted since 1945 have conferred legal form on inherent human rights and developed the body of international human rights. Now let us see further the differences between the types of these human rights instruments. What is a declaration? We saw the Universal Human Rights Declaration. A declaration is a formal and a solemn human rights instrument enunciating general principles and broad obligations. It is not a binding instrument and does not impose specific obligation on member states. However, depending on the solemnity and significance of a declaration, it may be expected that members of the international community abide by it. As against a declaration which is a broad declaration, a convention is an international agreement containing provisions to promote or protect specific human rights or fundamental freedoms. Conventions are open for signature and ratification by states, and a convention is legally binding upon the states which have become parties to it by ratification. Let us now see the core human rights conventions which are so important and relevant for social work. 1. International Convention on the Elimination of All Forms of Racial Discrimination of 1965. Second, Convention on the Elimination of All Forms of Discrimination Against Women of 1979. Third, Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment of 1984. Convention on the Rights of the Child of 1989. International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families of 1990. International Convention for the Protection of All Persons from Enforced Disappearance. And lastly, Convention on the Rights of Persons with Disabilities of 2006. Now, what is the obligation for the signatory states? International human rights law lays down obligations which the states are bound to respect. By becoming parties to international treaties, states assume obligations and duties under international law to respect, to protect, and to fulfill human rights as follows. The obligation to respect means that states must refrain from interfering with or curtailing the enjoyments of human rights. Second, the obligation to protect requires states to protect individuals and groups against human rights abuses. Third, the obligation to fulfill means that states must take positive action to facilitate the enjoyment of basic human rights. Through ratification of the international human rights treaties, governments undertake to put into place domestic measures and legislation compatible with the treaties, obligations and duties. Where domestic legal proceedings fail to address human rights abuses, mechanisms and procedures for individual complaints or communications are available at the regional and international levels to help ensure that international human rights standards are indeed respected, implemented and enforced at the local level. Now, as an ideology, human rights have been critiqued, and let us see what are the basis or the rationale for these critiques. One, the ideology of human rights tends to be individualistic. Basically, it's a liberalist ideology that dominates the human rights. We also saw in the Covenant, it's the civil and political rights that have dominated the UN proceedings because of the strong capitalistic lobby. So, the term itself implies that the individual takes priority over the community. Human rights ignore the social stratification and dynamics of marginalization between groups due to which these rights are denied to a large number of people in the first place. Thus, these rights are ahistorical. As a result, only those who are already better off and aware of their rights and claim their rights can obtain their human rights, although the rights are worded with the assumption of equality between the haves and the have-nots. Rights are proclaimed for which nobody is or could be responsible, although the state is considered the prime duty bearer of the rights. The exploitative systems go beyond the state, but there is no obligation on those exploitative systems such as the corporate sector. Mutuality between rights and responsibilities is necessary to allow scope for negotiating some reasonable balance of responsibilities between one group and another. For example, there could have been a declaration of all the human rights responsibilities of the corporate world, or declaration on human rights responsibilities of the family or the religion. No, the focus is on those who need human rights and not those on who have the responsibility to ensure human rights. Talk of rights seem to imply an absoluteness that is unsustainable in theory and dangerous in practice. We saw rights are ahistorical. They are also criticized to be atheoretical. Rights are therefore should be seen as instruments rather than as a prior ethical entitlement. The human rights ideology is not considered an ideology by some of the critiques, that they are only to be used as instruments. Another critique here is that human rights claim to be universal, but they are not universal. Again, we find some people claiming that human rights existed in all the cultures all over the world, but that is not true by some of the critiques. For example, in Asian cultures, ethics tend to focus on discipline rather than rights, on loyalty and not on entitlement, on responsibilities and duties more than on rights. Now, with its limitations, human rights have still made a whole lot of achievements, whether it's for the target groups for which the conventions are formed, like women, children, disabled, and so on, and also with reference to development as a whole. The development paradigm today is moving towards a rights-based paradigm. Let us see why that has arisen first. The rise of rights-based approach to development in the 21st century is in the context of the neoliberal globalization and also democratization in many authoritarian countries. More and more countries are accepting democracies in the 21st century. And the following factors also contributed to it. For the democracy campaigners, human rights appeared to embed progressive legal commitments, making them difficult to overturn. For the NGOs, rights offered a complementary campaigning position that alleviated internal and external questions, challenges, and questions about the legitimacy of their own work. For the middle class, rights offered a way back to a state position that had previously protected their interests by virtue of their class status, but that was now denied to them. For the bilateral development agencies, rights offered a way of extending their model of a liberal democratic state. Now, why should rights-based development be considered important? As long as we regard lack of food, healthcare, housing, and basic education as a deplorable tragedy and do not treat this as a violation of an individual's rights, we are not taking these needs seriously enough. Development policies, therefore, should be approached from a human rights perspective to turn vague humanitarian aspirations and advisable policies into clear-cut obligations. The existence of international human rights conventions means that development policy is no longer simply a matter of charity or morality or social preference or economic or social benefit, as it is legally enforceable. The explicit incorporation of human rights considerations into development work is meant to add value in the following ways. One, human rights have universal international legitimacy as an organizing framework. States have legal obligations to respect, protect, and help fulfill rights. Rights are universal, so their use draws attention to the most marginalized groups whose rights are least respected. Human rights have legal force, bringing with them the possibility of legal redressal. The realization of rights is not just of mere instrumental value for the fulfillment of other objectives. Rights are end in themselves. Rights should therefore not remain the preserve of lawyers, specialists, NGOs, and UN treaties. For quite a long time, human rights was a subject in law colleges, but not in schools of social work. Today, that is changing. The adoption of a rights-based approach should inspire a serious repositioning of development agencies and institutional partners with potential alliances with lawyers, unions, and social movements. Lastly, let us look at human rights movements very briefly. Like other social movements that we have seen in this course in other previous modules, human rights movements also are people's movements which aim to expose the authoritarian acts of the state and powerful social forces and help in connecting the various movements for the protection of democratic rights. Rather than locate rights in the individualistic tradition of Western liberalism, the human rights movements see them as struggle against class exploitation and social oppression. Struggles for the realization of social, economic, and cultural, as well as civil and political rights, have long been a feature of the resistance and liberation movements in many developing countries. These struggles are based in the awareness of injustice due to exclusion of the majority of the population from participation in the decisions that affect their lives in the context of lack of obligations on the part of the colonial state. Now let us summarize what we have done in the module today. We examined the ideology of social justice drawn from the ideology of socialism and comprising the ideas of rights, equality of opportunities, and equity in living conditions. We then reviewed the concept and principles of human rights as those rights that are inherent in our nature and without which we cannot live as human beings. We discussed the international human rights law comprising different types of human rights instruments such as declarations, covenants, and conventions, and obligations for the signatory states. Finally, we applied the ideology of human rights to development policy to make it legally enforceable with universal international legitimacy as an organizing framework. Thank you very much, and I hope you can go into details of human rights and conventions for particular target groups that you all are working with. Thank you.